to letter from concerned citizen. MP responds to letter from concerned citizen. The following is MP Scott Reed's reply to the above letter. Thank you for your letter that you sent to me on January 25, 2010, in which you further discussed suggested reforms to the Youth Criminal Justice Act. I couldn't agree with you more that criminal behavior must be met with meaningful consequences, whether the offender is an adult or a youth, to hold all lawbreakers accountable to their victims and their communities, and instill with them a sense of responsibility for their delinquent or criminal behavior. In the 2008 election, Stephen Harper ran on a campaign promise to change the Youth Criminal Justice Act to, among other things, make sure that young offenders who are convicted of very serious and violent crimes will face appropriate sentences, and that upon conviction their names will be made public. Just before our election, our Conservative government had introduced a bill, C-25, that would have made many much-needed changes to the Youth Criminal Justice Act. My suspicion is that the reason our government has not yet reintroduced a similar bill is because the opposition parties are likely to reject it outright as they did before. But I would welcome the introduction of such a bill again, and will always support bringing some common sense back to the youth criminal justice by reforming the current laws. I have also taken the liberty of forwarding a copy of your correspondence to Mr. Rob Nicholson, who is the Minister of Justice, for his review. If you would like to further correspond with Minister Nicholson, he can be reached at the following address: Rob Nicholson, Minister of Justice and Attorney General of Canada, 284 Wellington Street, Ottawa, Ontario, K1A0H8. And that so concludes the second letter. Now my third letter, that appeared in the Perth Courier on that same topic. It's called Harper Should Follow My Example. It was in the Perth Courier on March 11, 2010. Within the United States, and probably the whole country, young offenders are automatically being given adult sentences when convicted of serious crimes. And the United States Supreme Court didn't declare this practice unconstitutional from its November 2009 deliberation. The Canadian Supreme Court should follow this example of the U.S. Supreme Court, and they are not presently doing so, as illustrated from my examples of the Canadian Supreme Court in my previous letter. Stephen Harper has repeatedly made clear that he considers the Supreme Court too activist and liberal, prefers judges with a restrained approach to enforcing the Constitution, and picking Supreme Court judges when needed is the sole prerogative of the Prime Minister. So ends my third letter. Now this is a little excerpt I wrote about half a week ago. Supreme Court Justice Stevens is retiring from the United States Supreme Court. On Friday, April 9, 2010, Barack Obama praised Justice Stevens for being restrained, for not striking down federal and state laws very often. He has been a justice of the U.S. Supreme Court for 34 years. The Canadian Supreme Court is far less restrained than the United States Supreme Court in striking down laws, especially when it deals with the rights of young offenders. Alberta, Manitoba, as well as Quebec have used the notwithstanding clause a number of times when they believe the Supreme Court had made an unbalanced decision. The federal government will probably be forced, if they exercise their rights, and they should, to use the notwithstanding clause when dealing with the rights of young offenders, because the Canadian Supreme Court appears to be left-wing bleeding hearts for the wrong cause, based on past decisions they have made about young offenders when they have committed serious crimes. The Canadian Supreme Court doesn't get the simple fact that a young offender knows it's against the law to kill someone, burn down their houses, etc. The young offender is in control of his or her actions. They know what they are doing. The U.S. Supreme Court knows this, but the Canadian Supreme Court doesn't appear to be aware of this. The result is that the U.S. Supreme Court holds the young offender accountable for his or her actions for serious crimes, while the Canadian Supreme Court does not. There should not be two classes of criminals, that is, young offenders versus adults, when it comes to sentencing people for serious crimes, that is murder, manslaughter, etc. We need to get better, more restrained Canadian Supreme Court justices in once the present Supreme Court justices retire. Harper, or whoever is Prime Minister, should scrutinize them well. So concludes my topic for tonight.
Very good, David. I just want to say one thing. The letters you wrote, that you just read, you wrote them, and they appeared in the Perth Courier.
Yes.
And if anyone wants to read the letters themselves instead of listening to you again on video, they can go to your website and click the photocopied news clippings and read your letters, right?
Absolutely.
And that's at ourhost.ca/davidsblog.htm. If you're on David's YouTube channel right now, it's on the left-hand side of the screen. Just click the link and go to davidsblog.htm, ourhost.ca. And the Perth Straight Shooter's signing out.
Yes.
So good evening.
Good night.
Yes.
That's it.